Hi, everyone. Harry here to talk about one of the most stinging, severe, and critical opinions trashing the government, and in particular, calling out Lindsay Halligan that I have ever seen. All right. This is back in the Nachmanoff chambers. We're not in Curry now. We're back in the actual Eastern District of Virginia, where the selective and vindictive prosecution motions, among others, are being heard. And this is by a magistrate who's been dealing with the issues of potential privilege review and issues having to do with the presentation by Halligan of the indictment against Comey. And man, oh man, oh man, it ends with 7 findings of really striking misconduct, all of which could lead to dismissal, not to mention sanctions. It is absolutely excoriating. All right. First, we have all the materials that the government seized many years ago involving Comey and Dan Richman, his counsel and friend. And recall that in the government's motion before Nachmanoff, they lay all this discourse, even though it has nothing to do with anything. But it sure has a lot to do with violations of the Fourth Amendment potentially and of privilege review, because what the magistrate makes plain is, at the time, there was no coordination with Comey about potential privileged material, and the government now nevertheless went ahead and used it with, and only thereafter sought some kind of filter procedure, which is what you do to have a whole different team consider attorney-client privilege material. Because if you see it, if you even so much as see it as a prosecutor, you can be, and normally are, disqualified from the entire prosecution. Here, they had, when they went back to indict Comey, they had one of the same agents who had reviewed this potentially privileged material go into the grand jury and testify. And so whatever taint there would have been, if this is privileged material, would completely now be irrevocably present. So the very first point is how they screwed up there, and nevertheless could have corrected it here and didn't. Second, and relatedly, the magistrate says, you violated the Fourth Amendment when you did this search. The search that you were permitted to undertake, the warrant said you can look at everything, but you can only seize materials pertinent to crime A and crime B. It doesn't matter what they were, except now they have charged crime C that is very far afield, and it suggests that they almost certainly seized materials back then that they weren't authorized to get, and that is a new problem now. What the magistrate says is what you need to do, what would be conventional, what anyone would do, is get a new warrant and have it specifically tailored to the charge you are making of Comey, and they didn't do it. So that's all kinds of sort of Keystone Cops screw-ups and very, very basic stuff when you're coming into a prosecution of this magnitude. You know, it may be that the complete brain drain from the FBI and DOJ meant there was no one there to give this most basic of instructions. This could be attorney-client privilege. This could be not covered by a warrant for the current, so we need to get one for the actual current investigation we are launching. So that stuff, looks like possibly it was just a screw-ups, I should say, or possibly it was cutting corners when they knew they shouldn't have in their zeal to get Comey any way and every way that they can. But the first series of violations that the magistrate finds is they basically, on September 2025, they just give this disc over that has all the stuff they got before that might be privileged, that may have violated the Fourth Amendment in its gathering and the like. And if a new warrant had been sought, then the Fourth Amendment would have required it to be narrowly tailored, authorizing access only to materials within a limited time frame relevant to the new offenses under investigation. So it would have been a different and much narrower scope than what he's calling the Richmond warrants. And having decided to forge ahead, as he said, they took no precautions to determine whether the stuff they were using, presenting to the grand jury, et cetera, is in fact privileged. It involves a complicated series of questions whether something is privileged, but certainly I think from the start, Comey was setting up Richmond to be his attorney, not just friend, specifically in order to be able to take advantage of attorney-client privilege. So they've messed this up completely. Now, the court reviews the grand jury material and finds, first of all, that agent who was given the stuff before, so it was corrupted, is the only one who appeared on behalf of the government. The government says that it confirms the baselessness of Comey's claim privileged information may have been shared with the grand jury. The judge says, nope, the materials seized from the warrant were the cornerstone of the grand jury presentation. But now we get to the worst, and an absolute embarrassment and complete takedown of Lindsay Halligan, because the court, it's blacked out, but he says identified two statements by Halligan that on their face appear to be fundamental misstatements of the law that could compromise the integrity of the grand jury process. Let me just say it again. Two statements by the prosecutor to the grand jurors that on their face appear to be fundamental misstatements of the law that could compromise the integrity of the grand jury process. This is exactly what we've been thinking could be and waiting to see, because Halligan doesn't know what she's doing at all, and she's under this political compulsion to her boss to get the indictments to happen, and they are blacked out. But the prosecutor states it's a fundamental, and we don't know what it is, and highly prejudicial misstatement of the law that suggests to the grand jury that Mr. Comey does not have a Fifth Amendment right not to testify at trial. Man, I don't know what it is, but first day in prosecutor school, you learn it's not only you have a right not to testify, there's an actual Supreme Court case that makes it clear you may not comment as a prosecutor on the defendant's exercise of that right. And the prosecutor's statement, says the magistrate, ignores the foundational rule of law that if he exercises right, the jury could draw no negative inference. So man, oh man, not just crass, not just prejudicial, but so completely ignorant and untrained. So exactly what you think they would be risking in kicking her into the grand jury. And then there's another statement that may have reasonably set an expectation in the minds of the grand jury about burdens of proof. And now there's a third statement. The prosecutor told the grand jury that the ones I just mentioned were sort of both of a piece. Then second, the prosecutor tells the grand jury, we don't know, but it clearly suggested to the grand jury they did not have to rely only on the record before them to determine probable cause. You know, the notion that they were somehow pulling in, I don't know what it is again, but so elementary. And so this is, disbar kind of stuff. And then we get to the gap. I did another YouTube on this earlier, where the gap, she said, in the proceedings had nothing to do. She was just out of the room. But the magistrate basically says, I don't think I believe it. It just doesn't hold up because the record's well established. The grand jury originally is presented with a 3-count indictment, and they rejected count 1. And so she had to prepare and sign a second indictment. And at the return, they presented both the first and the second. But that means the magistrate questioned the foreperson and the prosecutor to amend this problem, and then accepted the return of the second signed indictment. But that was a new indictment, and therefore, after reviewing the grand jury, the prosecutor had to present the second indictment to the grand jury for consideration before it was returned in open court. It now appears that may not have happened. So she may actually be telling the truth and saying she didn't have dealings with the grand jury, but it would have been the failure to represent after something is rejected. So again, so elementary. And after all these are laid out, he goes through. No fewer does the magistrate than 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 possible problems, possible grounds for a motion to dismiss. Just really humiliates her. Now, who knows what happens? If they will certainly appeal to Nachman off, etc. But there's the there are so many of these, and they look so terrible that, well, first of all, it obviously casts a very negative light on the whole enterprise. But on Lindsay Halligan in particular, man, oh man, I'm not sure how they're going to unwind these many knots and the whole misadventure of kicking her in there. Remember, after Trump fires the professional nominated by him U.S. attorney who says we can't bring this case and sticks her in there, is looking stupider and stupider, and it's looking more and more that Lindsay Halligan will be subject to the axiom, everything Trump touches dies. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.